Hi, everyone. Good morning. Thanks so much for joining us today. See, we've got people flooding in here. Good morning, Brittany. Oh, we've got another Cassie on here. David, Derek, Erica, good to see you again. Liz, Kelly, Maddie. Oh, yep, everyone's coming in now. Thank you guys so much for joining us today. We're so happy to have you here for our live webinar, Employee Injury Claims 101, a guide to proactive management and resolution. I'm just going to go over a couple housekeeping items for everyone so you know what's up with this webinar, just so that everyone knows. This webinar is recorded, and you will get access to it with a follow-up email with a link to the recording, as well as a copy of Jason's slides as well. If you have any questions during this webinar, you are welcome to type them into the chat or the Q&A feature, and Jason will answer them. We have a Q&A session dedicated at the end of the session, or you can type something in right when you think of it. Just an FYI, though, that question might be answered at some point in time, so we might skip over it if it already comes up. So with that being said, I'd love to introduce you to Jason Hiller. I'd love to also mention that this is Jason's first webinar with us at Hausman Group. So we're super excited to start it off with his first ever webinar. So thank you guys so much for joining us. So a little bit about Mr. Jason Hiller. He joined our team in 2022 as a claims resolution specialist, and he specializes in workers' compensation. Before joining Hausman Group, he was a director of safety and compliance at a multi-state temporary staffing and recruiting place, HR consulting, and PEO organization. His 15 plus years of experience in workers' comp and return to work strategies have given him a knack for walking the tightrope between protecting the organization and doing what is right, while also treating employees with respect and empathy. Workers' compensation has always been one of Jason's favorite focus areas, and he's excited to bring that experience and knowledge to HD client. Here's a little fun fact about him. He can come up with a light duty solution for practically any scenario, so feel free to test him on that today. Thank you so much for being here, Jason. I will turn it over to you.
Good morning, everybody. Thanks for joining us today. Excited to talk a little bit about workers' compensation and give a high-level overview of work comp and hopefully continue on this path down the road with some more advanced webinars in the future. So our goals today are to talk a little bit about employee injury claims, initiating the claims process, the milestones in the claims process, documentation and communication, and then a little bit of an HR and employer perspective. And I believe most of the folks on this call are from an employer background or human resources, so hopefully this will be relevant to you. As Cassie mentioned, totally open to questions during the presentation, but we definitely have some time allotted at the end to go through more. So jumping right in, why does workers' compensation exist? So as with almost all employment-related laws, they're put in place to protect primarily the employees, but in this case, there's a little bit of protection for the employer as well. So workers' compensation was created as a no-fault system to protect employees and employers when injuries happen. Regardless of the causation of the injury, whether it's the employee's fault or something that the employer did, it's a no-fault protection for those employees and employers. It is an exclusive remedy situation. So basically, prior to workers' compensation, in order for employees to recover when they're injured at work, they would have to go through the tort court system or civil court system and basically sue their employers. So with workers' comp, when an employee sustains an injury at work, they do not have to go through the court system to kind of be made whole for their injury. This does not, however, prevent tort action against a negligent third party. So we see this probably most common in things like car accidents, where there's a third party driver that causes the car accident. That employee, the injured employee, would be able to pursue recovery against that negligent third party. As far as the benefits provided by workers' compensation, the goal here with most insurance is indemnification. And what indemnification means is making the person whole. So what this entails, and I'm going to give you a disclaimer here that this presentation is primarily focused on Wisconsin workers' compensation. If you have employees in other states, you do want to make sure you're aware of the different state laws, but this is going to be primarily Wisconsin-based today. So as far as the benefits available under workers' compensation, medical payments is the most common, indemnity or lost time benefits. There is a waiting period in most states before lost time benefits kick in. In Wisconsin, that is a 3-day waiting period. So you'll probably see if a person goes to emergency room, their default return to work status is off for 3 days because they know that that won't kick in lost time benefits. Those benefits are paid at 2/3 of their average weekly wage. 2/3 is because those wages are not taxed. So basically, if you're thinking the numbers look lower than what they would actually bring in gross from you as the employer, it's because they're not taxed on their work comp benefits. And those are paid in the form of temporary total, where they've been totally taken off of work, or temporary partial, where they've been released to come back to some sort of work, whether it be a physical restriction or an hours restriction. Other benefits that are slightly less common but still involved would be permanency. So in Wisconsin, we have scheduled permanency based on the body part that's injured. So basically, they go through the course of treatment. The doctor says you're as good as you're going to get, and you've lost 10% of the use of your leg. That's a scheduled payment amount. Also, if their injury prevents them from returning to the same job or industry that they're in, there could be a loss of earning capacity award, which maybe they're only able to earn 75% of the income that they did before the injury. Also disfigurement. See disfigurement come into play a lot with burns, things like that, where there's something visible on the person's body that may prevent them from getting the same kind of work. If you're a hand model and you burn your hand, that's going to possibly prevent you from getting work down the road. And then there are death benefits, and death benefits are paid to surviving spouses or dependent children. If there is no surviving spouse or dependent children, those benefits still get paid out, but they go into a state fund that helps pay for uninsured employers when injuries occur there. Jurisdiction is something that can get kind of tricky if you have a multi-state kind of environment. Each state has their own workers' compensation plan. Wisconsin was ironically the first in the nation to create workers' compensation. Each state, as I said, has different laws, and they can get tricky depending on a number of factors. Typically, when a carrier is looking to determine the jurisdiction, they'll ask a number of questions, such as where was the employee hired, where are they paid out of, where do they actually work, where do they actually live, and where are they seeking medical attention. In most cases, if you're a Wisconsin employer, your factory or your employment environment is in Wisconsin, it's going to just be Wisconsin. But when you get into situations where employees are traveling or have multiple plants across various states, jurisdiction can get tricky. Go ahead and contact your agent or your carrier to talk through specific circumstances if you aren't sure which jurisdiction will prevail. From my HR background, I tend to default to whatever is most advantageous to the employee, as that's typically kind of what the courts wind up with when there is jurisdiction disputes. There are federal plans for longshoremen, offshore drilling, and military bases where there would be no state laws applying to those. And then if you have any international exposure, your employees are traveling abroad, make sure to discuss that with your agent as well, because many standard workers' comp policies exclude international travel. But there is other insurance available in that situation. When we look at the actual costs of employee injuries, I like to look beyond the actual policy dollars. So things that a lot of people don't think about with regard to the costs would be any lost or damaged product that happened as a result of the injury, decreased productivity when you're pulling 2, 3, 4, 5 people off of the line to kind of deal with the injury or complete the investigation. Certainly business reputation, if you tend to have a lot of injuries, that could damage your ability to find talent, which as we all know is a big struggle across the board. And then employee morale. I mean, employees want to come to work and know that where they work is safe and that they're not running the risk of being injured on a daily basis. With regard to the actual policy, guaranteed cost is the most common type of workers' comp policy. Premium for a guaranteed cost is based on industry class code and your audited payroll. Usually it's a rate per $100 in payroll. And then the state of Wisconsin, if you're a Wisconsin-only employer, calculates your experience mod on an annual basis. If you have multi-state exposure, that would come from the NCCI or the national rating pool. It's a number that is calculated annually with a 3-year look-back window, so looking at all of your claims from the prior 3 full policy periods. a basic or neutral employee or employer mod rate is 1.0. So basically you're paying dollar for dollar for your work comp premium. I like to look at work comp kind of like auto insurance. The more claims you have, the higher your rates are going to go. So if you have a better than average experience based on your industry, your mod can go below 1.0. So if you're at a 0.75, for example, you're paying 25% less for your insurance. If you have a worse than average experience for your industry, you can go up above 1.0 to say 1.25, and then you're paying 25% more for your insurance just because of the increased risk. Most employers find workers' comp insurance in the free market. Your agent is out kind of marketing you to various carriers. If, however, you're in a super high risk industry where carriers don't really have that appetite, or your loss experience is poor and they're not willing to underwrite the risk, most states have what's called an assigned risk pool, which is a pool of carriers that kind of are voluntold to carry the employers that can't get insurance on the free market. This is a rotating kind of pool of carriers that, they all have to kind of take their turn. So if you can't find the insurance on the free market, there is always going to be an option. And then there are some other alternate risk financing strategies that your agent would love to talk to you about if you are interested in learning more about self-insurance, retroactive plans, or insurance captives. Also, there are a few states in the country that are monopolistic with their workers' comp, so you have to actually buy the workers' comp insurance from the state. Wisconsin is not one of those. Some other costs that are not covered by your workers' compensation policy, these are things in Wisconsin anyways that the employer pays out of pocket. The insurance company does not cover these. The first one is unreasonable refusal to rehire. So this would be the employee alleges that you failed to rehire them after they were injured or bring them back. They could be subject up to 1 year of wages, depending on the circumstances or their ability to find future employment. And then the other one is a safety violation, which could basically, it increases the compensation on the indemnity benefits 15% up to the statutory maximum. This is where the employee alleges that the employer knew about some sort of risk and didn't take the appropriate steps to abate them or protect them. What I've seen most common in safety violation cases are where they didn't train the employee on how to use a machine. So if you have people operating machines, I would highly recommend getting training sign-offs for any training that you do provide. That is probably your strongest defense against a lack of training safety violation. Other cases I've seen have been where guarding is broken on a machine, the employer knew about it and didn't fix it or take the machine out of commission. So those costs can kind of add up pretty quickly and they're not covered by your policy. So once a claim does kind of occur, so I'll talk a little bit how to initiate the claims process. The first thing you always want to do, and this kind of applies to insurance claims across the board, is make sure that further injury or loss is prevented and that emergency treatment is sought if necessary. So kind of put everything on hold, make sure the employee isn't going to get further injured and gets the emergency care that they need. One thing I do want to note, not to delay reporting to your carrier based on a lack of information. Go ahead and send in what you do know. Get the claim rolling, and the adjusters can always kind of follow up with you to fill in any gaps later on. Some key details that the carrier will absolutely need for your claim will be the employee's name, their social security number, date of birth, the date of injury, what happened and to what body part, and if possible, where they sought medical attention. As I mentioned, you want to notify your carrier of the injury as soon as possible. If you're not sure how to report a claim, go ahead and contact your agency for assistance. They can tell you how each carrier kind of requests claims be submitted. Many carriers have an online portal. If not, you can usually call in the claim, fax in a first report of injury, or email to the carrier. Once the carrier is put on notice, you're going to want to make sure that an incident investigation is completed promptly, and promptly is the key word here. Once the claim is kind of at the carrier stage, I just thought I would talk a little bit about the key players on the carrier claim management side. Your number one contact with the carrier is going to be an adjuster. This is the person that's responsible for the medical and financial management of the claim. When looking at the financial aspect of the claim, you'll probably see on a loss run or on kind of website um, what's paid, what's reserved, and adding those two buckets together comes up to the total incurred. So reserved is what the carrier anticipates they will pay on the claim in addition to what's already actually been paid. Total incurred is the dollar amount that goes into your experience mod. The other thing that you'll see on some loss runs is the expense column, or ALOE. And this is the cost to the carrier of actually managing the claim. So this could be things like record fees that providers charge. Many carriers have record review services that will make sure that they're being charged for the appropriate services and at the appropriate rates. And many carriers actually tier their adjusting structure kind of based on the severity of the injury. So many claims will start in the medical only unit. These are kind of lower severity claims. Once they reach a point of lost time, they could get bumped up to an indemnity adjuster. These adjusters are more experienced in calculating benefit rates and kind of handling more severe cases. And then they're typically, in larger carriers, there's a catastrophic adjusting unit, which handles really severe cases or deaths. Another person that can be involved in your workers' comp claim is a nurse case manager. Nurse case managers are typically registered nurses. They will act either in a telephonic way over the phone or in person and go to the appointments with the injured worker. Typically, they will require permission from the employee to join them in the actual appointments, but they can still go to the medical provider's office and talk to the staff there, even if they're not in those actual appointments. Kind of two roles that they play. One is assisting the adjuster in obtaining records and communicating with the provider. So if you have concerns about the claim or the person might be kind of exaggerating their symptoms, this is something the nurse can address with the doctor either before or after the appointment or during. They are also there to help the employee and explain kind of what the treatment plan looks like and kind of what they need to do to make sure they're on the road to recovery. Nurse case managers, I just wanted to point out, typically fall on the expense line of the claim. So this isn't an extra fee that's going to impact your experience mod. The next kind of carrier claim management person would be an independent medical evaluation or potentially a medical record review. This is something an adjuster will utilize as an impartial third party or second opinion for the carrier. Typically, this happens if a person is treating longer than would be expected for their injury, or there's questions about whether or not the work injury actually occurred as it was reported, or the extent of the injury from that incident. As it says here, they'll give an opinion on the nature and extent of the injury as well as their work relatedness. I will also note that the employee has the right to a similar second opinion with a doctor of their choice. In either case, the carrier and the employee have to stick with one path. So if the employee seeks a second opinion, doesn't like the second opinion's kind of direction, they can go back to that first doctor, but they can't keep jumping back and forth between doctors or quote unquote doctor shopping. In some severe cases, we could be also looking at vocational experts. These are people that help evaluate the injured worker's ability to secure gainful employment in the future with or without retraining. So this person would help identify retraining resources or school if the person is no longer able to complete the type of work that they were doing when they were injured, or help with job placement activities if no position is available at the employer. Next, wanted to jump into some milestones of the claims process. These are the things that we're working towards as we're navigating the claim. Number one, obviously, is going to be initial treatment. So once the person seeks treatment the first time, the carrier will begin to investigate whether or not the claim is work-related or compensable. The first key milestone then is return to work. We want to get that person back to work in some capacity to limit the indemnity benefits as much as possible. So this could be restricted or light duty. These restrictions could be either physical in nature or time-based. lift 5 pounds max or only work 4 hours a day, something like that. Just getting them back to work in some capacity. As Cassie mentioned, this is something that I'm really passionate about, getting people back to work. So if you ever want to brainstorm ideas of light duty ideas for your unique work environment, I'm happy to kind of talk through those with you. Once they have kind of begun to recover, the next milestone in return to work is full duty. We want to get that person back in the job that they were doing when they were injured, or without restrictions and their full hours and schedule, so they're not losing any wages. Once they've reached full duty, the next milestone is end of healing. So this is when the doctor discharges them from care, basically says you're back to 100% or you're as good as you're going to get. As we discussed a little bit earlier, this is the point at which the doctor would determine if there is any permanency related to the injury. There are some mandatory permanency ratings in the state of Wisconsin, typically aligned with surgical intervention. So if somebody has a shoulder replacement or a knee replacement or back injury that requires surgery, there's going to be some mandatory permanency. And then depending on what those permanent restrictions are, could require some vocational retraining. Other considerations in Wisconsin anyways are loss of earning capacity. So if it's determined that the employee is never going to earn the same amount of income as they did as a result of this injury, they could be due some benefits on that front. And then folks that are Medicare eligible have to have that factored into any sort of closure or settlement. Basically, as they get older and continue to treat, Medicare does not want to have to pay for treatment related to a work injury. And so there's typically, if there's lifetime medical awarded or the person didn't get back to 100%, there could be a cutout or a set aside for Medicare. So if bills do start going in related to their work injury, Medicare isn't going to be paying those. All right, the requirements for a compensable workers' compensation claim. The number one requirement, the person must be a W-2 employee of the insured employer at the time of injury. Seems kind of straightforward, but when you look at situations with independent consultants or contractors and subcontractors, this is where you want to be really careful because there are situations if that contractor or subcontractor does not have workers' comp insurance, you could be liable as their alternate employer. So make sure if you're working with subcontractors, you're verifying that they have work comp coverage. Certificates of insurance are typically the easiest way to do that. Just request that as part of your quoting or onboarding process for new vendors. All right, the next requirement for a compensable claim is that the injury is caused by an accident or occupational exposure arising out of and in the course of employment. So the word accident is important. Self-inflicted injuries are not typically compensable. And occupational exposure is speaking to things of more of a like disease kind of situation where they're exposed to dust or chemicals or bloodborne pathogens, things like that. Little legalese here, so I'm going to kind of talk about this at a very high level, but if you want to talk further, I'd love to kind of go into this with you if you have questions. But arising out of means basically the cause of the injury is related to their work. There's three kind of concepts around this, which would be increased risk. So their work puts them at a greater risk of injury than the general public. Actual risk is kind of straightforward. The machine's at work, they got hurt by the machine. Or positional risk. And this one's kind of a little bit grayer, that the injury would not have occurred but for their employment. So had they not been at work, the injury would not have occurred. In the course of is talking about the time, place, and circumstance of the injury. This is where we get into things like inside versus outside employees. So inside would be people that have fixed work sites. They come to this office every day. They go to this machine every day. Outside employees are going to be your traveling, outside salespeople or folks who have varying work sites. It's harder to get out of claims for outside employees because they don't have that fixed work site every day. So positional risk kind of comes into play a lot with that. Coming and going is another thing that we look at in the course of. So if you have an inside employee coming to the same office every day, the drive time to and from work is not typically a compensable injury if they get in a car accident. However, if they're outside employees and traveling as part of their job, the coming and going rule kind of falls out the window. Personal comfort, this is something that kind of accounts for the fact that people need to use the restroom while they're at work, while they need to, have their lunch break, things that aren't necessarily doing work, for the employer, but, the employer is in theory gaining some sort of benefit from the person having that bathroom break or eating their lunch. Travel is super important to kind of consider if you have employees traveling to conferences or going to different, work environments other than your usual work site. It's a lot of times injuries can be compensable while people are traveling from the time they leave their home area to the time they arrive back. And probably the biggest defense for these kind of traveling is the concept of deviation. So they're deviating from their work activities. Example I like to show for this would be you're traveling for a work conference. You have a day off in the middle of the conference. You travel 3 hours to visit your Aunt Sally that lives, in the same state that you never get to view. So going to visit Aunt Sally really has no benefit for the employer. So typically that's considered a substantial deviation from the work. And that kind of, if there was an injury during that travel, probably not going to be compensable. But as you can see, there's a lot of nuances here. Claims are always going to be fact specific. So that's why we're going to talk a little bit about investigation and getting all the details so that the adjuster can make an informed decision about the compensability of your claims. And the other requirement is that the person must sustain a quantifiable loss as a result of the work incident. So, there has to be a loss of whether it be a financial loss with medical bills, of lost wages, they can't work because of the injury, or this is most common in death claims, a loss of consortium. So somebody in their family is losing the benefit of having that family member, whether it be the primary wage earner or caretaker for somebody. These are all things that can give rise to a workers' comp claim. Pre-existing conditions is something that comes up rather frequently when claims occur. One thing to remember is when you hire an employee, you're taking them as you bought them. So if they're coming onto your payroll with a shoulder injury and they get another injury to their shoulder, it's not necessarily barred from a work comp claim. The things that we're going to look at in those situations are whether it was an aggravation. So maybe they have a chronic shoulder injury that just flared up a little bit as a result of the incident, or was it an exacerbation? Did the injury actually make it worse? And what they typically look at for exacerbations is that it made it progress beyond its natural path. So, if they had degenerative disc disease in their back and the injury actually caused that to get significantly worse than it would have on its own, those are the kinds of claims that end up compensable. All right, the next category we're going to talk about is documentation and communication. I mentioned earlier the way that you typically would report to your carrier is via the first report of injury. This is a Wisconsin form that I've kind of grabbed screenshots of here. All states have remarkably similar forms that gather basically the same information, but slightly different. The areas where I've put stars are kind of the key pieces of information. Obviously, the employee demographic information, name, date of birth, social, phone number, address, and then your information. This is how the carrier is going to kind of align the claim with your policy. So having your name, your mailing address to make sure you get any correspondence is super important, and then the name of your workers' comp insurance company. I always recommend sending in the policy number when you're reporting a claim. If you're not sure what your policy number is, your agent can certainly help you with that. The middle section of the first report of injury is all about wage information. Wage information is not typically required unless there's anticipated missed time from work. If you're going to omit one piece of the first report of injury in the interest of getting it submitted timely, go ahead and skip the wage information. We know that a lot of times the person reporting the injury might not have access to all of this right off the bat. If it is needed down the road, the adjuster will certainly request it from you. And then the bottom is all about the injury itself, looking for the date, time, if they've returned to work, where did they go for medical attention, and then the description of the injury. And it's very important how you kind of phrase the injury description with as much detail as possible to make sure that the adjuster can then look at the medical records that are coming in, compare it to injury, and make sure that the records and bills that they're getting are actually related to that injury. On the flip side, if you think that this is not a compensable claim, wording this to kind of raise the red flag right off the bat is super important. I can, if you're pretty confident that the person's issue is a personal health issue, you can put that in here, like personal health issue, asthma attack, or something like that. Always good to get it into the carrier just so there's a record of it in case there's a question down the road. That would be something that would typically be not covered by work comp, and they can issue a denial. All right, and then we're going to talk about the incident investigation, and I want to differentiate between the first report of injury and the incident investigation. There's two different purposes for those kind of processes. So the first report of injury, the purpose is to put the carrier on notice that a claim has occurred. With the incident investigation, there's a number of reasons why you want to do this kind of separately and more thoroughly. Number one, you want to gather the relevant details for your work comp claim or possibly OSHA if they get involved down the road. Number two, you certainly want to prevent future injury either to that same employee or others. And number three, this can help identify a possible negligent third party, in which case the carrier could go after them for recovery or what they call subrogation. So basically, trying to recoup some of the money that the carrier had to pay out. Now, the nice thing about subrogation is if the carrier is successful in recovering that money, that has a positive impact on your experience mod because they will automatically report that back as a kind of lesser valued claim than it was initially. It's important to gather information as soon as possible after the incident. We want to get all this information while things are fresh in people's minds, while before any cleanup is done, which would kind of diminish some evidence. And I also recommend investigating near miss situations. So maybe something almost happened but didn't quite. Next time it probably will happen. So we want to kind of also investigate those near misses. As far as who should conduct the investigations, I always recommend the injured worker's direct supervisor. They're theoretically going to be the most familiar with the work processes and procedures and kind of what is trained to. Some organizations, depending on size, have dedicated safety professionals that do these investigations. That's great too. If you don't have anybody internally, there may also be resources for you with your carrier or your agency. If you have a more catastrophic or serious injury and you want to have a third party kind of do an impartial investigation, those are great resources to leverage in that case. And then some organizations have their human resources department do these investigations as well. The thing that I'm always looking for in investigations is the root cause of the injury. Well, you want to know the specific details about what happened, what was happening leading up to the incident, and obviously the more detail, the better. We're looking for the classic who, what, where, when, why. Certainly from an HR perspective, looking at policies that may have been violated and progressive discipline that may be necessary. Certainly we don't want to be punitive with employees when they're injured. However, if they've made a violation of a policy, they should definitely be put on notice and shared what the expectation for correction would be. And then I like the ask why 5 times kind of concept of root cause investigations. Talk about that in the next slide. Timely photos and video evidence. Many times video evidence is recorded over every 24, 48 hours. So you want to make sure you can retain the clips if you have them. Certainly photos, as I mentioned before, any cleanup is done or any abatement. Certainly get those pictures right away. It's a lot easier now with people having smartphones and other devices readily available at work. And then timely witness statements, who saw what, getting the written statements while it's fresh in their brain, and having them sign and date those, super important. One thing that we also see missing a lot in dating is the actual year. So if we have a court case 3 years down the road and there's no year on that signature, it's hard to prove when the person actually signed the statement. So keep that in mind. Detail, detail, detail. So I thought it'd be good to kind of give some examples of maybe some poor incident explanation. So this one I have, John fell the other day and hurt his leg. Like that's a very vague disclosure of how the injury happened. I was going to be asking, why did he fall? What day did he fall? What time? Which leg did he hurt? What is the actual injury? Did he scrape it? Did he break his knee? What's going on here? So an example of a, possibly better description or an incident investigation. At 9:03 a.m. on Wednesday, July 5th, 2023, John was walking down aisle B in the North Warehouse when John stepped up on a pallet that was in his travel path. Pallet buckled, sending John's right foot through the wood, causing John to lose his balance and fall down. John's right ankle was cut by the pallet wood and John landed on his right knee. His knee became swollen and discolored. So this is like, you can almost visualize what happened here, right? And that should be kind of the outcome of your investigative research. You should be able to visualize how that injury occurred and what happened. And then we turn to the root cause. So we're going to ask, why did this happen? So why did the injury occur? John tripped on a pallet. Why did John trip on the pallet? The pallet was in the aisle. Why was the pallet in the aisle? The person who emptied the pallet didn't take it away. Why didn't they take it away? Because they had another pallet to unload in the next aisle. And why did they have another pallet to unload? Because they are short-staffed due to illness or employee turnover. So the root cause of John's injury in this case would be a lack of adequate staffing resources. And so this employee was probably rushing or hurrying to get the work done because there just weren't enough people to do it. And beyond the ask why 5 times, be curious. What else do you wonder when you're trying to visualize this injury? Was the pallet in poor repair? Is that why it buckled? What was John doing in the aisle in the first place? We figured that out. He was unloading the pallet. How fast was he walking? Could he have walked around the pallet? What footwear was John wearing? Does your policy require non-slip footwear or steel-toed boots or things like that? So just encourage your folks that are doing your investigations to just be curious and really try to understand what happened. A couple other points I just wanted to bring up. Mandatory reporting in Wisconsin, the work comp division does require all fatalities be reported within 24 hours, either by phone or by fax. And OSHA has some mandatory reporting requirements as well. I like this little flow chart that they had on their website, but within 8 hours, you're required to report any deaths. And if you're subject to OSHA, there are some smaller employers that are not. And within 24 hours, and this is probably the less commonly known one, anytime there is initial inpatient hospitalization, and this can be a little tricky. So, if somebody goes to the hospital, comes home, gets an infection, and then 5 days later is hospitalized, that's not what's required to be reported. Only if it's their initial treatment is putting them in the hospital. Amputation, I like to think of amputation as bone loss. However, other people may have different opinions. And then any loss of an eye has to be reported within 24 hours. So just make sure your supervisors and your staff that are responsible for injury reporting know about these mandatory reporting requirements. You may or may not wish to involve your employment counsel when working with OSHA or the DWD. That's up to you. All right, and then our final section is kind of the HR or employer perspective. From my perspective, best practices, obviously the role of HR and management varies by organization depending on size and kind of the structure of your business. One of the main things is, and this could sometimes fall to the accounting department too, depending on your organization, but managing the insurance relationships as far as policy renewals, submitting claims unless you're using a nurse triage line, providing payroll information and things of that nature, basically answering questions from the insurance company. I also think it's important for HR to kind of guide managers in their investigations and follow up, push for more information. If you're sitting in your HR office and the supervisors turned in their investigation and you still don't understand how it happened, the carrier is probably not going to understand either. So I kind of encourage you to push to get more information if you're not fully understanding. One thing that I think really, really helps the positive outcome of claims is having the direct supervisor as the primary contact with the injured worker. This kind of really drives home that the manager cares about him or her and wants them to get better. And that kind of trickles up to the organization. Um, a lot of people think that they're in trouble anytime HR calls them. So this is a good way to kind of avoid that wall being put up. If they feel like they're just talking to their manager that they've talked to every day, you can certainly guide them and tell them what to say or give them words if they are not comfortable or don't know what the answer is, that they'll follow up and get back to them. But I highly recommend the direct supervisor as primary contact with the worker, unless the claim starts to escalate and you need to kind of isolate the rest of the organization. Other roles of HR, coordinating benefits, whether that be their health insurance premiums while they're missing work, things of that nature, any sort of FMLA or ADA kind of crossover. And then, as I just mentioned, I highly recommend kind of having HR take over if claims escalate. Certainly things related to a fatality that could involve talking to the employee's family, things of that nature. If the employee is no longer employed by the organization, I think that's a fair time where HR can kind of take over, or if they're fired because of a policy violation or something. And then anytime there's active litigation, you really want to kind of isolate the communication to one person, whether that be an HR person or a legal counsel. And then I just kind of wanted to talk about Maslow's hierarchy of needs and kind of just plant the seed that, people don't want to get hurt, right? Like they don't come to work saying, oh, I hope I get hurt today. A lot of companies have a negative stigma about reporting injuries, where people are afraid they're going to get in trouble or they're going to get fired. You want to kind of breed a culture of reporting, because if it happens to one person, it could be 7 times worse the next time, and you want to know about that so you can prevent it. But if you think about what happens when an employee is injured, psychological needs are the first thing that kind of people need to feel safe and happy. So the first thing that runs through their mind is, how am I going to pay my bills? It's not, how am I going to get better from this injury? How is my family going to eat? And then kind of as it moves up the scale, we get to the belongingness and love. So they don't want to feel like everybody at work is going to be mad at them for getting injured or losing their safety bonus or whatever the case may be. So the more you can kind of treat the employee with empathy and show that the organization cares, and that you're looking out for them, the more positive I feel your outcomes are going to be. All right. I think this time we have some questions. Cassie, I think I lost the slide that had the SHRM code on it.
That's okay. I will make sure that that is in the email for everyone who would like those CE credits. All right, so at this time, we have room for questions. So if you would like to ask Jason a question at this time, you are welcome to type it in. Jason, do you want to go over the questions that came in during the presentation?
Sure, I see there's 2 in the Q&A. I'll start with those. The first one says, can you go into more depth about the 3-day waiting period you mentioned earlier? So the waiting period means that the person would need to lose 3 days of work in addition to the date of injury, so the date of injury doesn't count, before any lost time benefits kick in. So if you're injured on Monday, doctor takes you off of work Tuesday, Wednesday, Thursday, as long as you're back to work by Friday, there would not be any lost time due on that claim. If they lose less than a week, and this is getting in the weeds a little bit, if they lose less than a week of time altogether, those first 3 days don't get paid. But if they go beyond 1 week of lost time, then they go back and pick up the waiting period as well. And some states have a 14-day, like Florida has a 14-day waiting period, so they could be off work 2 weeks before lost time kicks in. All right. We have another question. We have an employee that is out on work comp and the provider has now okayed for the employee to come in for a classroom training. Could this impact the workers' comp claim? I think probably would need some more details on that. Generally, if they're released to come back to work and you have work available for them where they're not going to be suffering a wage loss, that would typically end any indemnity benefits at that point. Or if they're just coming in for partial hours to go to this training, it would at least offset some of the indemnity benefits that would be paid. But if you'd like to reach out to me privately, we can certainly talk about your specific situation.
Any other questions at this time? If not, Jason does have his contact info up there, so you can give him shoot him an email if you would like to, if you think of something after the presentation. But otherwise, we will give these 14 minutes back to you. Thank you all so much for attending our webinar. We really appreciate your time and taking some of your time to learn more about workers' compensation. So hopefully you learned something. We'd love if you could fill out the survey that comes up right after we end the Zoom webinar. That just helps us know, what you liked, what you didn't like, and what new ideas you might have for webinars that you would like to see us do more about. And just as a reminder, everyone will receive a link to this recording as well as a copy of the presentation slides. So with that, thank you all so much again for coming, and we hope to see you again soon.
Thanks, everybody.
Thank you.
Bye.